Hi folks, I'm Anna Sophia Walsh and welcome to the IP Flow Show, where we talk about all things intellectual property. My colleague, Lee Pakia, sat down with the IP practice group of Sullivan Cromwell to discuss the recent SCOTUS patent decisions. Let's see what they had to say.
The Supreme Court is all into intellectual property all of a sudden. We've had 3 cases this term and 3 are on order for next term. That's a pretty high percentage of the workflow for the court. Why is SCOTUS so interested in IP all of a sudden?
Well, I don't know that they're intrinsically interested. None of them are IP lawyers. But look, I think there are a number of different factors at play here. We've got intellectual property technology as an ever-increasing element of our economy. So it's pervasive, it's important. We're dealing also with the fact that we now have devices, these fancy little phones and other devices, your iPads and et cetera, which read upon dozens or hundreds of patents. So the interplay of technology and of patents is becoming more and more important. And you have a situation where up until a few years ago, actually still today, but even up to a few years ago, you had a lot of parties, a lot of people who were looking to monetize patents, seeking to get money through royalties and taking very aggressive actions to collect. And on top of that, you've had now actions that the court has taken itself as a reaction to some of those efforts. You've had the court reacting to efforts of Congress through the American Invents Act and through what the PTAB has been doing. And and then you have on top of that, you have the whole issue with the Federal Circuit, which frankly is unusual because unlike the rest of the cases that come up to the Supreme Court, the Federal Circuit is the exclusive court through which all intellectual property cases come. So the Supreme Court is essentially sitting over the Federal Circuit as the Court of Appeal.
You've seen deep divisions in the Federal Circuit on some very important questions. Cuso, one of the cases this term, was 6-5 in the en banc Federal Circuit. The SCA hygiene case, which the court has granted for next term, again, 6-5 en banc. And so that kind of division among experienced judges in this area signals to the court that these are questions that are worth taking. And I also think that we've seen a bit of a weakening over the last decade of the view at the court that the Federal Circuit should be left as kind of a gatekeeper of IP law, and the justices have become more willing to wade into this area and less willing to leave the resolution of these questions to a specialized court of appeals.
I think they have been setting a bit of a limits around what the Federal Circuit has been doing over the last several years, which is basically treating patents as a separate category of legal principles. And I think the Supreme Court's been interested both in terms of reinforcing the message that it's really not a separate set of legal principles, but also getting involved somewhat in the debate over patent quality and really what our system does in terms of treating inventions and how we treat the exclusivity that's inherent in the patent system. We've had over the last half of this decade more patent cases than the Supreme Court's taken in any 10-year period over the last 100 years or so. So they're clearly interested. And I think also IP is playing a more significant role in our economy, and so it's a more significant area for the Supreme Court to address.
These issues are more prevalent in front page news. IP issues are more front page news for Main Street. When you had the patent troll problem hit Main Street, you have Apple and Samsung having a massive IP battle that is front page news for every major development in that story. So I think IP is more in the minds, and patents more in the minds of the average citizen. And the policy questions that are coming out of the American Invents Act, which is relatively new and still being interpreted, gives rise to some serious legal questions that are issues of first impression, because that statute hasn't been around until recently and is only being tested now.
So I get that we're dealing with a variety of macroeconomic forces and also some particular things that are happening in the legal community to put all these cases in front of the Supreme Court. But it also feels like we're talking about this an awful lot. Is our society reassessing how intellectual property rights should be handled? Is this a recalibration?
I think it is in some respects. I think you had situations where people who were being under attack, so to speak, from the people asserting patents, have felt that their ability to do business, their ability to innovate was being limited because of these efforts to monetize patents. Of course, on the other side, the inventors and the owners of these patents feel that they've expended a lot of effort and time and money in creating this intellectual property, and that they're entitled to return, a fair return.
The Supreme Court involvement in intellectual property law is just part of the greater debate that we've been having over the last several years about where does intellectual property fit in our economy, and what's the appropriate role for intellectual property and the exclusivity we grant to inventors, and the whole debate that we've certainly been having lately about patent quality, and I think it fits. We had in 2011 the America Invents Act, which was part of the Quazzo case, which had the most radical changes to the patent law, certainly in my lifetime, and probably in the last 100 years or so. So I think it all does fit in part of this larger debate that all three branches of government are having.
First, there's a very active public policy debate over the extent to which we ought to be protecting patent rights versus trying to promote innovation. And so I don't think we should be surprised that that policy debate, which has played itself out in other branches, has found its way to the court. The question is very important to businesses and the innovation economy. And a number of these questions concern statutory interpretation, and that's the bread and butter of what the justices at the court do.
We're going through a dialectic process. So a few years ago, there were at the court of its own volition through a number of cases. The Congress took various efforts to, I think, limit some of the measures as to what could be patented, and also how those could be asserted and what kind of damages could be paid. Whenever something happens, there's always a reaction, and so now those decisions, the new statutes, they're all being assessed in light of what's actually happened. So now we're seeing a reaction to that. And we're going to find a new balance.
It's been said that recent cases like Alice have devalued IP rights. Would you agree with that, and how so?
I think it is true that if you look particularly at some of the work of, again, all three branches of government, the Supreme Court in Alice and MedImmune and Bilski and Medtronic and eBay, and you could go on, maybe up until you hit 2015 or so. But there has been a consistent beating of the drum that has devalued patent rights, whether it's harder to prove infringement, whether the amount of damages that you get are lower, whether it's more difficult to get an injunction, particularly on standard essential patents. You have the American Invents Act in 2011, which certainly made it harder to protect patent rights. But then when you start to look at what's happened over the last 2 years, I think one could make a case based on less data and maybe not conclusive data, that this pendulum that I've at least seen swing back and forth over the last 30 years or so has started to swing more toward recognizing the value in intellectual property and the value that intellectual property serves. And maybe we've gone too far in the earlier cases in devaluing intellectual property.
Alice has introduced some significant uncertainty into the scope of a patent. And if you think about it sort of fundamentally, when an owner of a patent or a potential defendant of a patent wants to understand what are the property lines, in analogy to real property, what are the property lines for the patent? They can't necessarily just look at the deed and read the claims and have a firm sense for what those property lines are. Now we have a very complex legal test that has to be applied to those property lines and understand exactly what is the ultimate scope of the invention, and is that invention even patentable? Is it even susceptible to being protected by a patent in the first instance? And if there was a very clean, bright line test, which probably would be difficult to formulate in any case, but there isn't. And there is substantial uncertainty following Alice. There are decisions that are starting to come out to interpret what did it mean. And in the meantime, major companies that have significant patent portfolios that read on software and other inventions that would be affected by Alice have to go back and really look at their own portfolios and say, which one of these patent claims that we have are likely to survive an Alice test or Alice scrutiny, which ones are not, and therefore maybe we shouldn't be paying money to prosecute them anymore. And so in the meantime, many companies have to react along those lines to managing their own portfolio. With respect to the monetization of patents, and you said the value of patents, certainly the value of any patent that falls into the category of being an invention that might not survive the Alice test has been heavily devalued. There are many, many, many patents that, of course, are not affected by Alice at all. But certainly those that are directly impacted or those are arguably impacted, their value has certainly been affected. And I think the result is the patent market has moved on such that assets that are likely to have an Alice problem would either not transact or would be subject to a significant discount.
And after a series of cases in Alice and Mayo, Limelight, and Medtronic that were, I think, viewed as unfavorable to patentees, we've had a couple of recent cases where the court has reversed the Federal Circuit in a more pro-patent and patentee direction. So a case like Comel, where you've reversed in a pro-patent direction with respect to induced infringement, or Octane and Highmark, where the court has made it a little easier to get attorney's fees in patent infringement cases. So I think you have seen somewhat of a shift back, and the question for this term and next term is, are we going to see the trend continue? Are those blips, or do they represent the courts shifting back to more of a balance between protecting property rights and promoting innovation?
What does this wave of cases mean for the financial markets? I would imagine there's a lot of companies, a lot of large investors out there that are watching this process very closely.
It really depends on where you stand in this debate. Are you the people, one of the people who's relying on the value of the patents, or one of the people who's defending? And I think there's uncertainty. We don't know exactly where it is, but I think we're at a point where it's less than it was. The patent are less valuable than they were several years ago. And my personal view is that once this is all said and done, they'll probably be somewhat more valuable than they are now. But it's a state of flux. We don't know. So there's uncertainty, and that has to be priced into whatever deals these people are doing, whatever transactions they're designing.
Truly valuable intellectual property, and not some of the garbage that's gotten the bad press and has perhaps taken over the dialogue. But truly inventive core patents, I think, people are looking at with a little bit of more of a fresh eye, I think, over the last couple of years.
You and your clients are entering an interesting period in your relationship. What do you tell them about what's happening out there right now?
I think I've been saying that I do think that the pendulum is swinging back, and I do think that a lot of my clients are people who invest heavily in intellectual property, research laboratories, universities, other people, and there had been a period where there had been questions about really what's the utility of the investment if Congress and the courts and the legislature is going to just devalue that. And I've been telling them, hold on. I think better times are coming.
I'm telling them to watch the Quazzo and Stryker decisions as a key indicator of where the court and where our patent system is going to be heading. And I've received a lot of feedback even beyond our borders from other players in other markets, that internationally there's a lot of attention being paid to the outcome of those decisions. Like capital is free-flowing internationally these days, patent holders hold patents in many different jurisdictions, and they have the ability to forum shop. And so the ultimate decision of where many of these cases will be brought in the future will depend upon the balance in our system. We do have a lot more development in our law, a lot more reliability in our decision-making infrastructure than many, many other jurisdictions, and that's not going to change. But to the extent that the gap is opened up and widens between the substantive rights of a patent holder in the United States and those in select foreign jurisdictions, I think what we have at stake is for the United States to continue to be the forum of choice for the resolution of these disputes.
And that was Lee Pacquiao speaking with the Intellectual Property and Technology Transactions Group of Sullivan Cromwell. If you would like to see more content like this, please check out our website at mimesislaw.com under the IP Flow tab, and check us out on Facebook and Twitter. That was the IP Flow Show, and I'm Anna Sophia Walsh, and I'll see you next time.